orders on Friday, man.
Friday.
My lord.
Let it come next week.
Well, then third, my lord, third hours. Monday.
Third hours.
Okay.
Third hours.
Let me mention listing of the one urgent material. It was listed on 21st, but your lordship will not call the call. Your matter may be heard on the next 28th, your lordship, Tuesday, my lord.
There are 75 matters fixed. Yours will be 76.
Whatever. Not the reach then.
But
Then 28. 28.
13/5. 13 August. Thursday. Yes.
My lord, if taken, I will circulate an adjournment slip, my lord. Item number 44, 45, 46, and 47, my lord. 44, 45, 46. Those are the cases where my senior Mr. M.K. Chaudhary appears, my lord. The matters have been heard substantially, my lord, by a coordinate court, my lord, sister court. And
there's another one.
Ridusmita Gogoi, my lord, we are not praying for that, but these are matters that tagged, my lord, automatically.
No, it is also connected.
Connected, my
Have
lord.
you spoken to the council for in item number 47?
No, my lord, no.
You should have.
We should have, my lord, but since we happen to
You are
be-
saying that these are heard before another bench.
My lord, my lord.
Mr. M. Sharma, Learned Counsel, appearing for
Petitioner.
petitioner, submits that these matters were heard substantially before coordinate bench, and therefore submitted that they may be permitted to approach the registry for listing it before the bench. Remit is allowed. Petitioner will apprise the registry. Will approach the registry for listing it before the step.
We'll do that, man. I'm great. Great.
May it please, Your Lord. It's regarding item number 49, petition day. Item will be adjourned for a week.
49.
49. I'm for the respondent 7, my lord.
Yes.
Only pair that either next week or August
Who's
6th.
for you're for the petitioner.
I'm for the petitioner. Can it be on 6th, 11th, my lord? Yes, 6th or 11th, any day. August.
13.
Yes, my lord.
13 August.
Yes, my lord. Most of them.
The request of the council of the petitioner, let us take the court.
Much obliged.
Item 49. Yes.
It is a document for listing one motion matter on Friday.
Motion matter.
Yes. My lord, with respect to item number 54, my lord, I'm bringing for 2 weeks time to file our affidavit in opposition, my lord.
Who's for the petitioner?
My lord, we have taken the consent of the petitioner of a phone yesterday, my lord.
Council, Mr. H.
Purva.
H. Moore, appearing for the respondent state praise for 3 weeks time to complete instructions and file necessary affidavit submitted by the petitioner. Step of thing.
Please, Your Lord.
What date may be fixed?
Uh, 27 August.
I'll do this, my lord.
May I please, Your Lord? Lordship, I beg for listing of 2 fresh matters for motion tomorrow. The matter relates to imposition of penalty on these 2 law colleges unjustly.
Right,
And
tomorrow,
not
let
being
it
allowed
come
to
on
take-
Friday. Let it be on Friday or Monday.
Have you honor the conducting council has some difficulty? Highly obliged it may come.
Have you filed it?
Yes, already filed, yes. Obliged.
May I please, Lord? With a consent of the other side, I beg to mention item number 53. I'll adjourn the matter for the day.
53.
Lordship.
You're for the petitioner.
Lordship.
53 on the request made by the council. Listed after 3 weeks.
Right.
Yes, Your Lordship. Lordship, I, with the consent of the other side, and let me mention item number 55. Lordship, I pray for 3 weeks of time to file rejoinder.
55 on the request made by the council petitioner. Then deferred to be listed after 3 weeks, enabling them to file.
My lordship, I beg to mention for listing of an admission matter.
Admission matter. Admission matter on 5th of August.
It was.
Please, your lordship. Please, your lordship. Lordship, I'm praying for listing of the admission matter.
Admission matter,
Lordship.
5th of August.
Fifth.
For listing for withdrawal.
Tomorrow.
And please, your lordship. Lordship, with the consent of the other side, I'd like to mention item number 7 and Lordship, may kindly adjourn the matter.
5758, which is for the petitioner.
Mr. J. Chutia.
Petitioner,
Yes, your lordship.
you're for the petitioner.
Yes, your lordship.
5758,
50 is a different council.
who says they are appearing?
It's an encrypted process.
5758 of the request made by the council, we have to petition, stand deferred to be listed up.
Lordship, may kindly fix it on 4th of August.
4th August. Right, 4th August.
Of that lordship. Your losses, when the petitioner died in this case.
So
On
you want to-
22nd, 2024.
No substitution.
No.
It is submitted by the learned council petition that the petitioner expired during the pendency of the writ. On which date?
22nd, 01, 2024.
24,
24.
21, 22, 01, 2024. This information, however, subsequently brought to the petition. Therefore, the legal layers are also not interested in pursuing the matter. So, considering the respondents, anyone from the respondents?
Secondary.
Secondary.
Respondents do not appear. Considering the submissions made, in view of the expiry of the writ petition on 22/24, and no substitution having been filed, the writ petition has abated. It stands closed. Novation.
Obliged.
In this case, Malak, we have sent the proposal to the finance department. That is for presently the finance department for concurrence.
Earlier, I think earlier also, so no time, earlier.
What is the direction of the court?
Direction of the court method, page 20. Paragraph 12. Paragraph. The state level scrutiny committee, upon consideration of the case of the petitioner in the light of the recommendations made by the district scrutiny committee, to also proceed to recommend the case of the petitioner for provincial office service. The director of the shall take appropriate for such recommendation and provincialize the service of the petitioner rules from 1/1/2021 with all consequences benefits. 3 months time are given. Now more than 2 years, madam, about.
Here, Malak, SLSC Malak on 7/2/2024 Malak already recommended. Malak here, Malak proposal has been sent to create a post of tutor Malak.
For finance,
Finance not a party. But
if they are not a party, then you are in trouble.
Malak,
We'll have to issue contempt notice.
well, I'll ask standing council finance department to bring the inspection regarding.
Sent on 27.
No, 8/5, proposal was resubmitted to the finance, the second parameter, finance department of 8/5/2026 through main file number so and so, I'll ask Mr. Soliha,
You call him, call the finance, let us find it after some time.
Here, Lordship, the SLC has already recommended their case for conciliation, Lordship. This is the minutes of the SLC. Now, the same thing here also, we have to create a post, the matter will go to the finance today, Lordship.
Have you sent it to the finance?
No, it will go to the Lordship. I have been told by the secretary, it is sent to the government. Director has already sent a proposal to the government. Government will send it today to the finance. The post has to be, two posts has to be created for item 2 and 3, two cases are together, Lordship. And the SLC has already recommended their name, the board of item number 2 and 3. Lordship, may kindly give us some.
But what is disturbing is that the department is not
The department, until after-
adhering to the time factor, the
I-
time limits within given in the
950 years.
judgment.
time factor is there, Lordship, but ultimately post has to be created by the finance, Lordship.
No, then you come and apprise the court that it can be done within the time specified.
Yes.
You're required to file an application for enlargement of time. You have accepted this order. He has not done anything. You are in contempt. Give us a good reason why we should not send you to the civil prison or draw up contempt proceedings.
Otherwise, there is no intention to not comply, Lordship. They will
Your
comply.
intentions are irrelevant.
Yes.
There is a direction to comply and you have to comply.
Yes.
You can't say that we have sent it to finance, it is lying before the finance, we can't do it. Then we'll call for the finance department. We'll issue notice on the finance also. There is a specific time limit.
Yes.
If you know that it can be done, you must apprise the court that it can be done. Give us 1 year's time, give us 2 years' time.
That should have been done.
You're sending a very wrong message to the departments. Irrespective of the time limit, we'll do it as per our pleasure. We can't permit that. We can't permit that. You're making it very, very clear for you to convey to all concerned that if there is a time limit and if you as a council feel that it can't be done within the time limit, you will apprise the court to give you sufficient time or file an application for enlargement. Every matter, 6 weeks, 3 weeks.
Yes.
Here and the matters are languishing for 2 years, 3 years, 4 years. What is this?
Yes, that should have been done. And
You send the proposal
Yes.
today and inform us by next week.
yes,
Council for the Mr. SMT Chisti, council for the respondent submits that proposal is scheduled to be sent to the finance department today. He submits that he will apprise the court in respect of the status, the steps taken by the department in compliance of the directions contained in the order dated so
this Friday, Lord,
last day.
this Friday.
WPC so and so. We are posting it on Monday. You
Yes.
apprise us.
Yes.
It's on Monday.
Okay.
Anything more to submit? We are making it clear. We are
Yes.
not going to give you time and again.
Yes.
Mr. J. Abedin appears for the writ petition. Monday. It's on Monday.
2 and 3. Same one.
2 and 3 same.
Yes.
In 36, since the petitioners are also left to argue, but the learned advocate general, he will be a difficulty today, since there is a special division bench, he'll be occupied there. So if your lordship want to hear the petition and hear us on Friday, Thursday,
That was the understanding that the
But-
petitioners will, if they want to argue, will complete your argument. So you tell us whether you rely on the submissions made by the council who had argued the other day.
Lordship, I am for item number 5 and 18, Lordship. Lordship, after hearing the argument the other day, Lordship, I feel it necessary to take instruction from my client, Lordship. But I fail to do so because the person who is consulting us, he is from Najira, Lordship. Very difficult, I could contact him today, yesterday, Lordship, but he could not consult his
Alright.
Lordship.
Item number
5 and 18, Lordship.
5 and 18. What about the others?
Item number 22, adopting the argument made by senior
Item number
20.
22. 22. Yes. And what is your item number?
5 and 18, Lordship.
5 and 16.
18, Lordship.
18. 5 and 18. Yes. Yes.
Lordship, we are here for item number 16, 17, and 24. They failed to get any instructions from our clients, Lordship, kindly be accommodated for different date.
16, 17.
And 24.
Then anyone else? Anyone for the petitioner?
Item number 9. Item number 9.
9. Yes. Are you arguing the matter separately or are you adopting the arguments made by Mr. Chaudhary? Yes, what? Are you adopting the arguments or you want to say something more? Mr. Chaudhary, Chaudhary had argued the matter the last date. Do you want to follow the argument or you want to say something more?
As I see, Mr. Kane say,
Ah.
is in this matter, he will up.
So he will argue, we need to know because we are thinking of passing an order here. Either you argue or you adopt the arguments. Where is Mr. Sheikh?
Another.
So these matters are listed, you should inform him. Take on. On 23/7, these matters were argued before the court. These matters, some of the matters were heard by the court. The arguments were laid by Mr. Rai Chaudhary, the senior counsel, assisted by Mr. H.P. Sharma, appearing in WPC number 7. Stop. Upon conclusion of these arguments, before the state wanted to respond, the court on a query made as to whether any other counsel would like to argue the matter, since there are several matters listed together. So several counsel appearing representing several writ petitions therein appeared and submitted before the court that the matter be listed today, enabling them to decide whether they would like to put up a separate argument or adopt the arguments largely adopt the arguments made by the learned counsel, Mr. Raichowdhury. There are Mr. The Psychiatric Learned Senior Counsel and Advocate General appearing in the state, who submitted that the petitioner should conclude the argument so that he can directly give a consolidated reply on behalf of the state. With such understanding, the matter was fixed today for the hearing. Whenever the matter is called up, counsel appearing in item number 5 and 18, MS M. Mora, Mr. B.D. Goswami appearing in item number 16 and 17,
And
22,
and 24/16.
okay, and 24 submits that they are unable to complete their instructions from the petitioners and they pray for further time. So submitted that in view of the unprecedented flood situation in the several districts of Upper Assam, which some of the writ petitioners belong to districts, the completion of instructions have become difficult in such a short time. It is submitted that the matter be deferred to be listed again after 4 weeks.
Not 4 weeks, madam.
They ask only 1 week time.
1 week.
On a date convenient.
Pray for some time to complete their instructions. This prayer is not objected to by the council appearing with the respondents. Mr. Your name? P. New, appearing in item number 24, 22. And Mr. Your name? MH Chaudhary appearing in item number 9. Also makes similar prayers. That are considering the above. So it is the view that matters can be deferred sometime. Accordingly, is to have the matter listed on 20 August.
6th of August. 6th of August.
6th,
Thursday.
6th is not possible. You can have it on 13th, 13th or 20.
13th of August. On 13th.
13th August. 13th August as agreed to by the council. Release this matter again on 13th August. As prayed for.
I know there are interim orders in some of
Interim orders wherever passed will continue.
It will be for further hearing.
Further hearing.
With regard to the teachers, professors who were left out of provincialization, because of non-verification of MA degrees, later on these verifications were carried out, but they are yet to be provincialized. Therefore, these petitions were filed.
service on this lordship and lordship. I need to obtain the instruction. I did not get the instruction lordship. I tried affidavit. Affidavit will be required in this. All the 4 cases are similar.
But these people have not having the last regulation.
They're still working,
They're still working.
but not provincial.
Not provincial. Last provincial took place in 2022, 21 and 22. So 4 years they have waited, and the verifications were also completed a long time back, 2023. So
We obtain your instructions and file affidavit.
Yes.
Mr. M. Dr. Senior Counsel appears with the petition listed by Mr. L. Descartes. Mr. A. Provilda appears for the Higher Education Department. Mr. Provilda submits that the instructions are awaited. We'd like to complete the same and file necessary affidavit. Accordingly, Praise for 3 weeks. 3 weeks time. Prayer made. Is enough, considering the issues involved. Is this matter again after 3 weeks?
Can I prefer date, madam?
28th
Madam.
August.
Diploma.
Obliged.
Same. These are all connected. Whatever these matters, 37 copy to be listed together. It is submitted, some proposal is sent to the finance.
Yes,
To obtain
madam.
the instructions and find out what is the status.
Therefore, Lordship will kindly accommodate me for 2 weeks, my lord.
Yes,
I will get the instruction.
yes. The council appearing for the respondent, Mr. P.K. Bozak, submits that so far as the secondary education department is concerned, they have taken all steps to comply with the directions contained in the order, and a proposal has been sent to the finance department for review approval. Matter is presently pending before the finance department. So, the request of the court, Mr. R. Pujari has appeared in the matter as a standing counsel for the finance department. Mr. Pujari is permitted to complete his instructions as to the status of the approval, if any, required to be granted to the proposal stated to be put up by the elementary.
Yes.
Let these instructions be placed again before the court. 14th August,
Yes, my lord.
14th. Mr. You're Mr.
M.R.
M.R. Khandekar appears for the
And so obliged.
I beg to appear through VC in this matter.
Yes.
Lord, this is my section 11 petition. My lords had issued notice on 22nd of May.
Yes.
No reply has yet been filed, my lord, but I believe someone has entered appearance on behalf of the respondent. Lordship, 4 weeks time may be given, lordship.
4 weeks time.
My lord,
Any
it's a
objection?
section 11.
Any objection?
My lord, it's a section 11 application. My lord, we have issued and my contract concluded way back in October 2022, my lord. All this while, my lord,
I
the
will give
respondent
them
has been dealing
3 weeks time. 3 weeks time to file their objections.
very well.
But your MS
Amrita Singh.
is Singh appears for the petitioner through VC, and MS also appears for the respondent. Counsel to the respondent raise for 3 weeks time to file their objections. So, considering the fact that this is an application under section 11(6) of the Act of 1996, the respondents will endeavor to file their objections, if any, before the next returnable date. Release this matter again after 3 weeks on a date to be fixed by the registry.
Grateful.
May I please, your lordship, matter parties to monthly family pension and pensionary benefits.
May it please your lordship. Lordship, I seek some further time to obtain instruction, my lord. 2 weeks time may be given. Otherwise, my lord, pension is not a transfer subject to BTC, my lord. Only that whether the pension proposal has been sent to the department, my lord, that is to be obtained.
Let's see that appears for the petition. PTC is submitted that Instructions are still awaited. She prays for
Weeks time.
2 weeks for the time to complete the instructions. As to whether the proposal has been sent to the Department of Pension
To the Department of.
by the PTC authorities. Prayer made is used. Council to the petitioner, released his letter again in 3 weeks. On a date to be fixed by the registry.
A date will be fixed.
You may fix after 3 weeks by the date will be fixed by the registry.
On December.
The method for releasing, providing the area salary, 15% area salary, which has been pending since.
Yes, area salary.
50% lordship, we have already released lordship.
Hmm.
And the remaining 50% is to be granted by the central government also. And lordship, we have communicated to the authorities also, but till that we have not received. Who is the higher education department in the central government?
Central government, higher education.
Lordship.
You know, read them as a party. You're serving as what?
Not make them party minded, actually. Director of Higher Education.
What is this post?
Annexer A, it is clearly says that.
What is the post that you're serving?
Someone, principal and professor. All are.
Under the higher education department.
College.
Why is central government required to pay?
UGC's lordship some fund, it is required as per instruction, then the instruction.
UGC fund?
UGC's that is area lordship. The 50% is from share is from state government, which we have paid lordship. And the remaining 50% we have communicated to the authorities. October India Higher Education Fund.
But my lord, as per Annexer A, it is clearly says, my lord, nothing has been.
Annexure A?
Annexer A, page 12, my lord. Director of Higher Education, my lord, communicated the letter dated 7 March 2019. Not mention the central government is a part of the.
File on
Last several occasions they have took time, my lord. All the petitioner under NPS scheme, my lord, they are getting some sort of pension, my lord. Therefore,
we'll find affidavit.
But when will the 50% be released?
Yes, that is the instruction, that is the instruction.
You file your affidavit.
Yes, that will clarify.
You file it within 2 weeks.
That's it.
The respondents are permitted to file their affidavit within 2 weeks.
That's
As prayed for.
Alright.
Release this matter immediately after 2 weeks on a date to be fixed by the registry.
Alright.
And in this case, our affidavit is ready, but we will send it for vetting. After 10 days.
There's Sotia Council for the Respondent Department prays for another 2 weeks time to file their affidavit. 1 week.
Right.
1 week time to file their affidavit. Release this matter again after 1 week. On a date to be fixed by the registry.
The matter will be possible for the time. Council is in another court.
Otherwise, here, my lord, the pleadings are complete, my lord. This may come up for hearing. Matter pertains to, my lord, grade pay parity. The finance has already filed a comprehensive affidavit, madam.
Submitted that the pleadings in the matters, pleadings are exchanged in the matter. Matter is ready for hearing. This matter for hearing, the month of September. Yes.
And so apply.
Yeah.
Madam, may I pray this be passed over for the time being? Mr. Deka is in next. I'm appearing for the.
Is there limitation?
Yes. Passed. For the time being.
Let me.
Read. So 51 and 52 are similar. They have objected to the authority of the person who has filed this Section 11 petition because it was a JV and JV agreement empowers him, but they say there is no power of attorney or any board of resolution which permits it. They have objected to that. Lordship permits me to submit a Supreme Court judgment which says even if that is the case, that should be raised before the arbitral tribunal, not before the referral court. So I'll refer to paragraph 1, which introduces the entire fact.
Yes.
Also, which is leave granted is to a civil appeal arise from an order passed by the High Court for the state of Telangana at Hyderabad under Section 11(6) of the Arbitration and Conciliation Act 1996. For resolution of dispute as per the arbitration clause so and so of the general condition of contract. The contest by two appellant is on the ground that first respondent being one of the members of the consortium would not have invoked the arbitration in its individual capacity. This is based on the simple plea that arbitration agreement is only between appellant, AP Zenco, the purchaser, and the consortium. While the considering an application under Section 11, we are of the opinion that the High Court was justified in constituting the AT on the basis of a prima facie test of arbitrability. We have further held that it is for the AT to examine the preliminary issue in detail by considering the contextual provision and the surrounding evidence. We have thus upheld the order passed by the High Court considering the AT. Lordship will come back to paragraph 14. The legislative policy under 1996 Act strongly favors minimal judicial intervention at the pre-arbitral stage, as long a long line of precedents such as Duro Felguera Assay versus Gangavaram Port Limited Constitution bench decision in interplay between arbitration agreement under Arbitration Act 1996 and Stamp Act 1899 and SBI General Insurance Co. Limited Spinning have authoritatively settled that inquiry under Section 11 is confined to a prima facie determination of the existence of arbitration agreement and no further. The referral court is required to undertake only a prima facie determination of the existence of an arbitration agreement and refrain from entering into contentious factual and legal issues related to authority, capacity, arbitrability, maintainability, or merits of the claim. Which will come to 15, paragraph number 15. It is certainly a matter of institutional discipline for the referral courts to enable parties to identify and exercise alternative remedies, particularly that of arbitration with clarity and consistency. The question whether a member of a consortium can itself invoke Section 11 of the 1996 Act is not one that admits of a monolithic or uniform answer. Answer to that question will necessarily depend on the inquiry into terms of the principal contract, as well as the consortium agreement. The specific terms of the consortium agreement, parties to that agreement, and the nature of the rights and mutual obligation of that agreement creates will have examined in detail. The reference court will, however, confine its inquiry only to a prima facie satisfaction as to whether a member of the consortium qualifies as a party
to the arbitration agreement. This prima facie satisfaction is sufficient for the referral court to constitute and refer the dispute to AT. Possible, come to paragraph 19.
No, not like that. You take us through the judgment properly,
Yes, Lord.
or we'll have it
Lordship, I'll take your Lordship.
on some other day.
Lordship, the question before the Honorable High Court, before this matter came before the Honorable Supreme Court was whether a party to the consortium.
That's right. You take us through the judgment.
I'll take from the starting.
Yes. Para 1 you've already read. You can start from para 2.
Yes, Lord. Facts that are necessary for disposal of these appeals are that the appellant Epizenco floated a tender inviting bids from a consortium of companies for an EPC contract pertaining to works for their Rayalaseema thermal power plant. The tender specification incorporated the instruction to bidders and the general condition of contract, comprising of dispute resolution through arbitration under clause 22.2. Consortium comprising respondents 1, 2, and 3, namely so and so, so and so, so and so, was constituted on 17/8/2010 for participating in the tender process with TechPro System Limited. The first respondent designated as the leader of the consortium. The consortium emerged successful, and a letter of intent dated so and so was issued to the consortium through the first respondent, being the lead member. Thereafter, 3 purchase orders so and so were issued in favor of the consortium and execution commenced, each member undertaking his respective scope of the work. During the execution, the first respondent encountered several financial distress, resulting in project delays. Consequently, VA Tech, being jointly and severally liable for as a consortium member, undertook the first respondent's scope of work and was subsequently recognized as the lead member, via correspondence dated so and so, resulting in the amendment of consortium agreement. Billing continued to be raised in the name of first respondent for administrative purposes, while payment flowed directly each member in agreed proportions. Later, the first respondent was admitted into corporate insolvency resolution process, followed thereafter by an order of initiating liquidation. After the first respondent ceased to be lead member of the appellant, Epizenco issued a letter dated so and so to the first respondent that it was responsible for substantial delays in execution of the project. In reply, the first respondent denied the allegation and asserted that the appellant had committed various breaches, because of which the company suffered losses amounting to approximately so and so crores. By letter dated 11/12/2017, the first respondent demanded payment of the said amount and also indicated that if the claim is disputed, the letter should be treated as a notice invoking arbitration clause under GCC. In its response, appellant Epizenco rejected this allegation and asserted counterclaims predicated on losses alleged to have been suffered due to the first respondent non-performance. Gammon India Limited also protested the first respondent's unilateral communication, asserting that it lacked authority to act without the consent of the other consortium members. As per the appellant did not release the claim amount, the first respondent issued another letter dated so and so stating that dispute had clearly arisen between the parties. Through the communication, the first respondent formally invoked the arbitration clause and nominated former judge of this court as its nominee arbitrator and called upon the appellant to appoint its arbitrator. The appellant neither responded to the said notice nor has taken steps to constitute VAT. Aggrieved by this inaction, the first respondent instituted proceeding under section 11(6) before High Court, and the appellant promptly objected to maintainability on the ground that the first respondent as an individual member cannot unilaterally invoke arbitration. High Court, however, allowed the section 11(6) application and referred the dispute to arbitration. The said judgment is assailed in the present appeals. Okay, I'll read through the submissions. In view of our conclusion that grounds raised by the appellant and the respondent can and should be considered by the AT, it is necessary to note in detail each and every submission made by the appellant and the respondent. That it is necessary to determine whether a submission is beyond the remit of the AT or that the question must be considered at the referral stage itself. Submission behalf of the appellant. We have heard Mr. So-and-so, that is the ASG appearing on behalf of the appellant. I'll go to paragraph 9.1. At the referral stage, the court exercising jurisdiction under section 11 of 1996 Act is obliged to prima facie satisfy itself as to the existence of an arbitration agreement between the parties. prima facie satisfaction necessarily includes an examination of the arbitration agreement and the parties to such arbitration agreement. Upon such examination, it would be evident that no arbitration agreement exists between Epigenco and the first respondent. The arbitration agreement contained in clause 22.2 of GCC is enforceable against Epigenco by the contractor, and that is the consortium, and not by the individual member. The term parties in clause 1.1 so and so of the GCC is defined to mean the purchaser or the contractor, and the purchaser is defined in clause 2.1 of Epigenco, and the contractor is defined as the person whose tender has been accepted by the purchaser and the legal successor entitled to such person. It is therefore argued that the expression person expressly includes the consortium, and therefore it is only the consortium which is a party to the arbitration agreement. The definitions of contractor, bidder, person, and party read conjointly demonstrate that contracting counterparty was the consortium and not any individual constituent entity. Hence, the first respondent in its individual capacity could not have approached the High Court for appointment of an arbitrator. No arbitration agreement exists between the first respondent in its individual capacity and Epigenco. The reliance placed by the first respondent upon the arbitration clause contained in the GCC is misplaced. The GCC is a pre-bid document. Upon acceptance of the bid by consortium, the contractual relationship culminates into purchase orders. In fact, the three purchase orders contain identical jurisdictional clauses conferring exclusive jurisdiction upon civil courts at Hyderabad or Secunderabad with no provision for arbitration as the dispute resolution mechanism. The purchase orders constitute the principal contracts governing the relationship between the purchaser on one hand and the consortium as the collective entity on the other. Relying on the judgment of the Delhi High Court in so and so, it is urged that an individual consortium member lacks the competence to invoke arbitration in absence of authority from other members of the consortium. The group of companies doctrine is wholly inapplicable as per judgment of this court in so and so, which clarifies that mutual intention is indispensable and cannot be implied so as to override an express contractual structure which envisages action only through the consortium and excludes unilateral action by individual members. The first respondent lost consortium leadership in 2014 due to non-performance. Wayback took over and completed the work. The first respondent later entered CIRP in 2017, but still issued a unilateral arbitration notice, contrary to the stand of the consortium members, who oppose arbitration against Epigenco. Claims relating to consortium cannot be raised unilaterally by defaulting an insolvent member. The High Court failed to appreciate the distinction as affirmed in so and so between the existence of an arbitration agreement and the capacity to invoke such agreement. While an arbitration agreement undoubtedly exists, only the consortium and not the individual member has the contractual capacity to invoke. The claim of the first respondent to be legal successor of the consortium and therefore falling within definition of the contractor as per GCC is entirely misconceived. The term successor in title envisages one to whom ownership title is transferred and would not be applicable to a consortium such as the present one. The appellant attempt of the first respondent to invoke the arbitration independently, despite default, insolvency, and cessation of leadership, constitute a misuse of the arbitral process and is contrary to the contractual framework and the commercial common sense. Reliance is also specifically placed upon the order it is so and so passed by Honorable M.B. Lokur Justice in arbitration proceeding relating to Telangana State Power Generation, wherein identical claims raised by the first respondent were rejected on the ground that it could not act independently of the consortium. Submission on behalf of the respondent. I'll go to 10.1. Objection raised by the appellants are fundamentally misconceived because the contractual framework properly constituted recognizes that the first respondent had both right and the authority to invoke arbitration. The tender floated by Epigenco envisages participation by a single bidder as well as consortiums, and that the consortium of respondent number 1 to 3 was duly constituted in accordance with the tender terms. The purchase order issued pursuant to the letter of intent explicitly incorporated the tender specifications, which in turn incorporated the GCC, including clause 22.2, which contains the operative arbitration agreement. In view of the principle laid down in so and so, the arbitration clause stands validly incorporated by reference into purchase orders. The jurisdiction clause contained in the purchase order, which confers jurisdiction on courts at Hyderabad, is not inconsistent with GCC, hereby indicating Hyderabad was intended to be juridical seat of the arbitration. Identical issues were examined in the proceedings arising out of the same project with so and so and the successor of the appellant in Telangana after the bifurcation of the state, where the court appointed a former judge of this court as arbitrator after rejecting identical objection to the first respondent's capacity to invoke arbitration. The objection now raised are substantially the same and do not warrant reconsideration at section 11 states. The AT alone is competent to address them. The appellant's assumption that the contractor refers only to the consortium acting jointly misconstrues the definition. Clause 2.1 of invitation to briefs define contractor in two facets. First, the person whose tender has been accepted. Second, a legal successor in the title of such person. The latter applies when the consortium ceases to exist. The consortium agreement dated so and so at clause so and so states that it ceases to operate on a party agreement on becoming insolvent. The provision is carried through the supplementary agreement. Therefore, the expiry of the consortium agreement will result in each party being represented by themselves or their legal successor. Even if consortium were to be treated as continuing, it has no independent legal person under Indian law unless expressly constituted as such, which affirms that consortium or joint venture, unless incorporated, is neither a juristic person nor a separate legal entity distinct from its member. Clause 4 of the consortium agreement expressly states that consortium is not a separate legal entity. Hence, the appellant cannot assert only the consortium as an independent juridical unit could invoke arbitration. The consortium was a bidding arrangement. Members retain separate scope of work, distinct performance obligation, and independent payment streams. Payments were made directly to each member. Division of work under the consortium agreement and the amended purchase orders demonstrates that each member held an identifiable, severable, and independently enforceable contractual interest. The existence of the contract claims or potential liabilities against the first respondent is irrelevant for the purpose of determining the right to invoke arbitration. Counterclaims may be raised in the arbitration and adjudicated together. The appellant VATEC has no locus to oppose the first respondent's independent invocation when it claims arise from its allocated scope of work and relate to money allegedly due to it. The appellant's objection concerns the entitlement to invoke the arbitration, not the existence of the arbitration agreement. Such issues fall squarely within the AT jurisdiction under section 16. Analysis and reasoning. The reason for referring to the submissions of the appellant as well as the respondent in detail is only to flag and highlight certain preliminary and jurisdictional questions that will fall for consideration before the AT in the event we hold that the referral court need not examine this question in view of the section 11(6)(a) and 16 of the 1996 Act. We must, at the outset, address an important submission advance on behalf of the appellants. Namely that in the present case, there exists no arbitration agreement insofar as the individual constituent of a consortium is concerned. The submission is founded upon the certain decisions of the Delhi High Court and Bombay High Court, which have taken the view that a member of a consortium in its individual capacity cannot invoke the jurisdiction of the court under Section 11 of the Arbitration and Conciliation Act 1996. The appellants contend that the absence of a direct arbitration agreement between the employer and the individual consortium member, the very assumption of the jurisdiction by the referral court would be impermissible. In our considered view, the objection must be answered in broader perspective of the nature and scope of jurisdiction exercised by the referral court under Section 11 of the Act. With the introduction of statutory restraint under Section 11(6) capital A, the legislature has consciously confined the domain of judicial scrutiny to mere existence of an arbitration agreement. The legislative design is further reinforced by the express empowerment of the AT under Section 16 to rule on the own jurisdiction objection with the respect of very existence of arbitration agreement and also the objection relating to validity of such agreement. The statutory scheme thus envisages a clear demarcation between limited threshold scrutiny at the referral stage on one hand and the substantive jurisdictional adjudication to be undertaken by the AT on the other. The legislative policy under 1996 strongly favors minimal judicial intervention at the pre-arbitral stage. A long line of precedents such as so and so have authoritatively settled that inquiry under Section 11 is confined to a prima facie determination of the existence of an arbitration agreement and no further. The referral court is required to undertake only a prima facie determination of the existence of an arbitration agreement, refrain from entering into contentious factual and legal issues related to authority, capacity, arbitrability, maintainability, and merits of the claim. It is certainly a matter of institutional discipline for a referral courts to enable parties to identify and exercise alternative remedies, particularly that of arbitration with clarity and consistency. The question whether a member of a consortium can itself invoke Section 11 of 1996 Act is not one that admits of a monolithic or uniform answer. So I'll continue.
Yes.
Answer to that question will necessarily depend on inquiry into the terms of the principal contract as well as the consortium agreement. The specific terms of the consortium agreement, parties to that agreement, and the nature of the rights and mutual obligation that agreement creates will have to be examined in detail. The reference court will, however, confine its inquiry only to a prima facie satisfaction as to whether a member of the consortium qualifies as a party to the arbitration agreement. The prima facie satisfaction is sufficient for the referral court to constitute and refer dispute to the AT. Hereafter, it is for the AT to undertake the detailed inquiry as to whether a member of the consortium is in fact a veritable party to the arbitration agreement or not. This is exactly limited inquiry permitted and prescribed in so and so the relevant portion of which is under. I'll read the quoted portion.
Whether 6A is enforced. 6 capital A
Yes, Lord, it was
notified.
yes, Lord, in 2019 it was. 6A was notified in 2019. Lordship, if the judgment says if it's not notified, the Honorable Supreme Court will not record it in the judgment. It will not go on to say the 6A.
We don't know. We're asking you because the book doesn't say so.
Lordship,
Say it's not notified. Not notified. The amendment was, it has not been given effect.
2019.
You find out.
Lordship will take up after some time. We'll find out and get back on that question.
But in any event of the matter,
Lordship.
here the contract was this the joint venture.
Joint
Yes.
venture.
Where is the agreement?
Agreement. Lordship is holding arbitration number 25 of 2025.
Yes.
Lordship, agreement starts at page 19, the joint venture agreement.
90.
Paragraph 8 would be relevant for the
No, agreement with regard to the arbitration agreement.
arbitration agreement. Lordship, that is the contract. It starts from
31.
that's correct.
This 31 joint venture name is there in the contract. Page 31.
Is the contract and these clauses would be at
Joint venture name is mentioned there. The message, the Kemosa interest of joint venture.
Kemosa Introso Prabha.
yes, three partners.
You're referring to page 31.
31
25.
of arbitration 25.
Yes. Kemosa Introso Prabha. JV.
Yes, until time.
Where is the arbitration clause?
Lordship will come to page 39. $64.
for arbitration was made by all the three, under the letterhead of the joint venture.
And signed by the same person who has signed this. They have responded to that notice, accepting the fact that
You take this objection before the tribunal. We'll leave it open for you to question it before the tribunal. You are not disputing that there is an agreement. You're not disputing that there are certain differences which have arisen pursuant to the award of the contract. You are also not disputing that the manner of resolving these disputes is by way of arbitration. The only question is whether the appropriate person was raised the dispute. Yes. Or section 21. Take it up before the arbitral tribunal.
That is one plea, my lord. Another, my lord, plea is that, my lord, regarding 64, that page 39, my lord.
that is again how the dispute was raised that exists as per the contract. That also can be taken under section 16 by the honorable if that is.
The demand has to be made within 90 days, my lord. At page 40. Where the arbitration clause itself, my lord, there is a provision that if the contractor does not prefer his final claims in writing within 90 days of receiving the intimation from the railway that the final bill is ready for payment, they will be deemed to have waived his or their claims, and the railway shall be discharged and released of all the liabilities.
You raise all these claims before the arbitrator. Unless you dispute that there is no agreement. Unless you dispute that there is an agreement but no arbitration. Unless you dispute that this arbitration clause can be invoked but based on some conditions.
So in that case, my lord, will give liberty.
All limitations.
But as a preliminary objection, my lord, the tribunal will decide before going into the merits.
Third, counsel to the parties. Section 11(6) petition filed by the petitioner. Petitioner is a joint venture comprising 3 entities, namely Chemosa, Infosoft, and Propa. The petitioners have entered into a joint venture agreement. Joint venture consortium agreement executed by and between them.
3rd March 2018.
3rd March
2018.
18. So, said agreement. There is a nomination and authorization issued in the name of one Arshad Ali of Messrs.
First part, Chemosa.
Chemosa,
Yes.
CEMSA, will be the representative of the JV and is also authorized to sign tender, contract agreement, receive payment, witness joint measurement of the work done, etc. Joint venture was awarded a works for this work award allotted is as page 23.
Not it. That is the letter of
LOA.
LOA. Description of the work is the final location.
final location. Yes.
Work, which is described in the letter of award issued on 14/6/2018. So the description of the work as mentioned in the letter of award is as under a subject of the page number 23. Thereafter, agreement was executed by and between the joint venture and the respondents. Agreement dated 009/2018. So the total approximate values of work was 48,23, 31,435.07. The agreement inter alia contains a clause for arbitration in the event of any disputes arising by and between the parties. So, the arbitration clause, which is prescribed at, which is mentioned at clause 64(1) within bracket Roman 1, reads as under. The place of arbitration is also described to be within the geographical limits, the division of the railways, where the cause of action arose, or the headquarters, the concerned railway, or any other place with the written consent of both parties. Is it terminated or?
No, it is completed. Only the price variation that arises after the completion of the work, which was
The work was successfully completed, but the respondent authorities declined to accept the claims towards price variation clause raised by the joint venture. So this led to a dispute, and the petitioner joint venture issued a notice. Where's the notice?
57 page, the annex 16.
Dated 17 March 2025. Demanding for arbitration. So, this was it replied to?
Yes, Lord. It was replied and asked us for the waiver with section 12(5), which we
This was replied to by the railways on 8/4/2025, seeking waiver in terms of clause 5 for appointment of arbitrator from the curated panel maintained by the railways. The petitioner declined issue the waiver, and consequently, the arbitrator was agreed upon between the parties. So the petitioner thereafter filed this application under section 11(6). The railways have raised two objections. Firstly, that the notice issued under section 21 has also. Are you objecting to the notice also?
No, notice has been issued under the letter of the deed.
The application has been filed by a person who is now authorized by the person to file the application seeking appointment of the arbitrator. And what is the second objection?
Second objection is not that the, as per clause 64(1)(4), the final claim has not been raised within 90 days.
The further objection is that the final claim has not been raised within 90 days as is required under clause 64.
1(4), Roman 4.
64.
1.
Roman 4. In rejoinder, the council will petition reiterates his submissions made and has placed before the court the judgment, the apex court rendered in reported in 26-3 SCC 491. Submit to support in support of his arguments that the person who sworn the affidavit on behalf of the joint venture is now authorized to represent the joint venture. The report of law is to be authorized to execute tenders, contracts, and accept and receive payments on behalf of the joint venture. The further argument is that the final bill has not been raised in terms of clause 64.
Well,
1-4.
414.
And therefore, the claim for arbitration is not maintainable. So, therefore, submits that the application should not be entertained and the prayer for appointment of an arbitrator should be declined. Then it comes into the parties. So far as the first objection is concerned, the terms of the agreement means that the person named in the joint venture agreement itself is the person who's sworn the affidavit and is authorized to be a representative of the JV and to sign tender, contract agreement in respect of the tender, receive payment, witness joint measurement of work done, sign measurement books, and all letter correspondences relating to the above mentioned work on behalf of the joint venture. So, there is no specific reference that the person would be authorized to represent the joint venture that is pertaining to the rules of law. The question therefore arises is however, the agreement, provision of the agreement clearly reveals that the joint venture has duly authorized the person to be the authorized representative in respect of the tender, the contract agreement, receive the payments, and also to be a witness in the joint measurement of the work done, and to sign measurement books, and to issue a letter of correspondence. Therefore, the joint venture has clearly authorized the person concerned to represent three components of the joint venture. As specified. So, the question whether the person is authorized to represent the joint venture, the present proceeding, is an issue which can be cured by a proper communication issued by the joint venture that and the question whether the person is otherwise competent to issue, competent to represent the joint venture will require understanding spirit and scope of the intent of the parties, intent of the components to the joint venture in the agreement dated. So, It's clear from the joint venture agreement that the person who has sworn the affidavit before the present proceeding is the authorized representative. The objection is raised only on the ground that there is no specific reference to the authorized person to be authorized filing litigations. This, according to the court, is a curable defect, even if it is to be accepted that the person is not authorized to file litigations. We have to be joint venture. So, however, material has been placed before the court by the respondents to suggest that there was any disagreement within the joint venture, within the components of the joint venture, with regard to the acceptance of the person concerned to be a representative of the joint venture at any point in time. Such circumstances, this court is not inclined to accept the objections raised by the respondent counsel. Coming to the judgment of the apex court rendered in so and so versus so and so, there is a clear finding by the court that the referral court exercising jurisdiction under Section 11 of the Act of 1996 is only obliged to prima facie satisfy itself as to the existence of an arbitration agreement between the parties. So, prima facie satisfaction necessarily includes the examination of the agreement, arbitration agreement, and the parties to the arbitration agreement. So, the legislative policy under the 1996 Act clearly favors minimal interference by the referral court at the stage of referring parties to arbitration. The referral court is only required to undertake a prima facie determination of the existence of an arbitration agreement and refrain from entering into contentious factual or legal issues related to the authority, capacity, arbitrability, maintainability of the merits of the claims. So, it was held by the apex court that it is a matter of institutional discipline, the referral courts, to enable parties to identify and exercise alternative remedies, particularly that of arbitration with clarity and consistency. The question which was before the apex court is whether a member of a consortium can invoke Section 11 of the Act of 1996, and to which the apex court held that said issue is not one that admits of a monolithic or a uniform answer. So the answer to that question will necessarily depend on the terms of the principal agreement as well as the consortium agreement. So, coming to the facts of the present proceedings, there is no dispute amongst the parties that the December 21 and the reference sought for arbitration is not been raised individually by a member, any member of the consortium. In the facts of the present case, the agreement was executed with the consortium. The bills, payments were made to the consortium. Communications were on behalf of the consortium, and the notice under section 21 issued on behalf of the consortium, and also the present petition has been filed on behalf of the consortium. The objection regarding the maintainability of the petition with regard to the authority of persons sworn the affidavit on behalf of the consortium, as the respondents claim that there is no specific authority given said person personally in litigation. They are considering the use of the apex court in the said judgment. It is clear that these objections can very well be raised before the arbitral tribunal. Stop. At this stage of reference, at this stage, the referral court is only required to examine the existence of the agreement, satisfy itself that there is indeed a valid arbitration. So, having examined the findings available, having examined the pleadings available before this court, it is clear that there is a valid arbitration agreement between us, which provides that in the event any dispute arising by and between the parties, the matter is to be referred for arbitration. So, under such circumstances, the court is not inclined to accept the objections raised by the respondent. As at this stage, this court being a referral court, required to ensure that there is minimal interference in relegating the parties towards alternative dispute resolution through arbitration as agreed to by and between parties, ID their agreement date and so on and so forth. The objections raised before this court by the respondents can very well be raised before the arbitral tribunal, in which case the arbitral tribunal will be required to answer these objections as a preliminary objection. That view of the matter, the prayer made by the petitioner is allowed. Honorable Justice Mir Alfaz Ali, former judge of this court, is appointed arbitrator, sole arbitrator, decide the disputes arising by and between the parties, and subject to furnishing declaration under section 12(1) of the Arbitration and Conciliation Act. So, later, copy of this order be communicated from the registry. Justice Nidal Fazal. Parties are also permitted to place the copies before Justice Hani. So, on receipt or written declaration, the appointment shall be confirmed. We place this matter again on 14th August.
Next item is similar, only date will be different, I'll give it to you.
All right.
Same order. Highly obliged.
On hearing, I think 53.
Yeah.
Asking for the timely lodging some links.
This is the disciplinary proceeding. Timing
Two,
Taken
my
up.
lord. Document take up at 2, my lord.
2 p.m. PM, yes.
Principal retired, my lord, in the year, my lord, 31 May 2017. Yeah.
Today I have got some difficulty because Mr. Diocoin has been arguing this matter and he is suffering from fever. Maybe taken up tomorrow, day after tomorrow.
Long back matter is pending, my lord.
Who is
And-
arguing the matter?
Mr. Diocoin, he has filed the affidavit also. And he is suffering from fever since yesterday also.
He
Yeah,
submitted written report that
It is with him, Lordship.
counsel for the respondents
Diocoin.
entrusted with the matter, Mr. Dew, exposed. Submits the matter be taken up again. Some other dates.
Yes.
That means
Counsel for the petition. Mr. H. Das submits the matter be listed on 20 August. Released on 20 August.
obliged.
Obliged.
Here, matter relates to, my lord, misappropriation of fund of the school, my lord. And here, audit report is sought now from the director to the Nagaon inspector of school Nagaon. And 3 days, and the inspector of school has to submit this audit report within 3 days as per this letter, my lord. So sometime may be granted because auditing is going on, process of audit.
There is some inquiry going on.
Not following the procedure of law, I was relieved from the charge, Your Lordship. As far as my information, no inquiry is going. And the
Earlier
Mr.
hearing was conducted, my
Misinformation is
lord.
baseless, Your Lordship.
My lord, running page number 219, my lord, there is an inquiry report, my lord. Affidavit filed by the respondent number 6, my lord, running page 219.
Who is respondent 6?
I am the, my lord, president of the SMDC, my lord.
1.
219. Annexure O. This is the, my lord, inquiry report, my lord.
That report was prepared by the deputy editor behind the day complex.
Did he participate in the inquiry?
Yes, my lord, the previous page, my lord, page 218, my lord, 218, annexure P.
Where are the statements and all of the persons?
My lord, here the petitioner, my lord, is the assistant teacher. He was given the additional charge of headmaster. So there is a number of, my lord, allegations against him. Then, my lord,
Mere allegations will not do. We'll have to at least prima facie there has to be some proof.
my lord, there is a hearing, my lord, page 218, my lord.
Yes, 218 hearing is there. You come to 220. You will find on the findings that some report is there, analysis of various particulars, statements of the person. Where are these statements of the person at the hearing? This will have to be given to him.
But, my
Okay, you are enclosing it.
lord,
Where is the report of the inspector? Where is the report of the inspector?
And that copy is not submitted.
Not served.
Sir, not submitted. Basically,
Where is the, is there any show cause issue prior to the inquiry?
yes, my lord, there is a show cause.
Where is it?
Show cause is page, my lord,
In our
211, my lord.
Hmm?
In my affidavit 211, there is a one show cause, my lord.
Affidavit filed by the respondent number 2, page 62 is show cause, and page 63 is report from the inspector of the school.
62.
Yes, 62 and 63.
Affidavit filed by which respondent?
Respondent number 2, my lord, director. Director.
Respondent two.
Up to 57.
Is that page
62, my lord.
62?
Post. Headmaster IC. Kadhuri, AU, High School.
Find reply of the secretary to position number.
Reply next page.
Page number,
This is the
Report.
report from the inspector of school. Was sent to director in the.
That's the page number 66.
Where are the reports of the inquiry?
I have not received the record, madam. I have to ask them for record, madam, to place
It
before
is
the.
maintained by whom? By the inspector of the school.
Regarding them, madam, it will be the inspector who will maintain.
Third counsel for the parties, the challenge before the court, the removal of the reputation from the additional responsibilities as in charge of master. Patagudi, AU High School. There is allegation being meted out against him. So, from the pleadings, it is seen that a show cause was issued, leveling charges against the reputation, as also against the respondent, reputation by the respondent of 2 weeks. Reading revealed that there are statements of witnesses which were recorded, and on the basis of which the impugned order was passed relieving the petitioner's charges as in charge master. So, the pleadings, however, does not contain statement of the witnesses. So the proceedings, the inquiry. council, we produce the relevant records, we call for the relevant record and save before the next date of listing, without the next date of listing. The records must reveal the manner in how the inquiry was conducted and the various statements which may have been recorded, the various witnesses. Release this matter again after 3 weeks.
Decision also. Alert, on last occasion, alert 21/5 lordship, almost hard the matter. Today is the time for giving reply by the opponent learned senior counsel member as to whether a criminal case is said to be pending on the date of submission of the search sheet or filing the. Here in this present case, my lord, I on last occasion submitted list of date my lord. Pursuant to due selection process, my lord, initiated by the State Selection Police Board on 18/12/2021, my lord, the petitioner appeared and she was selected, my lord, and appointed as Women Sub Inspector on 1/11/2020. My lord, at the time of her appointment, lord, she was required to submit affidavit as to whether any criminal case is pending. And on the advice of her advocate, my lord, she submitted affidavit stating that no criminal case is pending. Now, after that, my lord, it is found that one FIR was pending against her. Now, my lord, presently that FIR also, my lord, she is discharged from the allegation. By order 13/6/2025, I have annexed at page 71, my lord. By the learned judicial minister first class. As of, my lord, the affair is also not there. Now, my lord, the search sheet was laid on, my lord, 21/7/2023. Paragraph 13 of the writ petition I have stated in the search also that the date is there, my lord, 21/7/2023. Now, to buttress my point, my lord, whether filing of FIR, can it be said that the case is pending, or on the date of taking cognizance or search sheet is laid, a case is said to be pending? And to that effect, my lord, this honorable court judgment 2001 3 GLT 389 I submitted, my lord. And this is the view of this honorable court directly at page.
What is the?
Yes, my lord. Party name is my lord, Jyotish Borua versus Airport Authority of India. 2001 3 GLT 389. I also gave, my lord, the hard copies last one.
Okay. What is this to a GLT?
It's a GLT. 2001 3 GLT 389. Found on the para 20. Yes. Well, that the copy must be there, my lord. Yes, yes. 2001 3 GLT 389. I sent it. Send. 3 GLT 389. Para 17, 19 and 20, lordship may directly come para 20. We are in the respectful agreement with the decision of Allahabad High Court, Bombay High Court, Nagpur High Court, Rangoon High Court, even if the decision of the Calcutta High Court and Madras High Court are also made applicable for that all will not change the color of the present case. As a matter of fact, there was no need for us to decide this question, but it has been decided by us because it was ours and argued vehemently by the Learned Counsel for the Appellant. We hold that the criminal proceeding comes into existence only when the matter comes before the court and not earlier to it. For the purpose of staying the departmental proceeding, the court must consider the fact that criminal proceeding takes shape only at the stage court can consider the question of staying departmental proceeding. It is in connection of staying departmental. However, the decision goes to so manner in a case, criminal case, not only on the date of filing the FIR, it can be said that the case is pending. It is only when the search is laid on that date only it can be said the case is pending. Now, my lord, I was required to
What are the
demonstrate
facts?
in the
What are the
affidavit.
facts in this appeal?
Yes.
What are the facts?
Para 3, my lord. Whether departmental continuation of criminal case, my lord, and whether departmental inquiry can be stayed on that point, my lord. There are 3, my lord. Miller. My lord, now, so for this case is concerned, disclosure with regard to any case pending, my lord. Disclosure with regard to case pending, and last occasion, the opponent senior counsel was placed, my lord, that their rule, what was to be disclosed in the affidavit. My lord, my affidavit is at page 35 in the writ petition, my lord.
Where is that form?
My lord, form, my lord,
Where it has to be disclosed?
yes, they have one form, my lord. And
It's not enclosed here.
my lord, form, my lord, they sought for me, my lord, the affidavit, not the form. An affidavit that I have to
What-
include
no,
any
no.
case pending.
That affidavit,
Based on the form.
requirement of the affidavit is indicated in the form. What does the form say?
Yes.
You don't have a copy.
I have,
Is the affidavit here?
and also,
Affidavit I place, my lord, page 35.
and also office memorandum dated 18 November 2001. The affidavit is not a penalty.
So what is the requirement in
Yes.
the form?
Requirement, I am reading it, man. Office memorandum 18 November 2021. Here, notarized affidavit shall also be made available under provision article. If the specific information contradicts the candidate's notarized affidavit, his appointment will be cancelled and he will be removed from the service. Any candidate found to have been submitted false notarized affidavit may also be liable to face legal action as per law. Now, this affidavit, the format is there, my lord. 1, 2, 3, serial number 4. I hereby declare that there is no pending criminal case against me. Serial number
Criminal
4.
case.
Case. Criminal case
What
pending
is the
against.
meaning of criminal case?
I will come to it, my lord, with a case law. Criminal case pending against me. And 6, serial number 6, that I am not a member of associated with anybody or association declared unlawful. But petitioner found that he was linked with the alpha activity. That's why she was arrested and sent to the jail. There is nothing in the character, my character. There is nothing in my character and antecedents which renders me unsuitable for appointment to the above mentioned post. 8. If any is found contrary to the declaration made here above in this affidavit, if the appointing authority is satisfied that such finding renders me unsuitable for the service, may discharge, remove, or dismiss me from the service without assigning any reason or divulging to the findings. In such an event, I will have no claim or grievance against the appointing authority, public authorities, and I shall be liable to prosecuted under the law. Serial number 9. The statement made in paragraph so. These are the conditions, my lord. In the affidavit, as per the office memorandum, they will have to submit an affidavit notarized by duly notary. So this has to be declared. But in this present case, whatever petitioner did not declare that one case is pending. In case, my lord, I have found petitioner case was lost FIR and case was registered, and they after investigation, by during the period of investigation, they were found and they were arrested and they were sent to the jail. Thereafter, they come to the under the sky on bail. So this is the case, my lord. So where I will discuss on the case law, my lord. This is that was not declared, but her duty was to declare it that I was arrested, I was sent to the jail. That was not declared. Anyhow, that is the false. But by this notification and office memorandum says, if any contradictory, any false statement is found in the notarized affidavit, he is liable to be dismissed. That is the case, my lord. Now I will come, my lord, what is the criminal pending cases. And also, in the departmental procedure, there is no any irregularity, man. Accordingly, so cause was issued. She replied that was not satisfied. Then departmental proceeding drawn. Therefore, inquiry was by the inquiry officer and presenting officer was appointed. Inquiry report was submitted. On the basis of inquiry report, second so cause notice was issued to her, and she was asked to return submit written statement or inspect all the documents, including the inquiry report. But in her reply, she did not mention anything, my lord, regarding this, my lord, all these things. She only say rather she has admitted in the preliminary reply against the second supposed that I apologize
for any wrong and I may be exonerated. That admission is itself, my lord, safe, my lord. That was a case. And now, my lord, I will discuss. Lordship, I will press a reliance on one case, my lord, in 2001. Lordship, kindly see, this is the case. My lord. This is the my lord, case in 2021, 13 SSC, T23. Anil Bhardwaj. This is squarely covered this case, my lord. In their Abid Bhardwaj case, my lord, he mentioned, is a online application tester, he mentioned that FIR was lost. Even though, and he was acquitted. Even though Supreme Court held, in considering so many cases, these cases are he mentioned in the list of that case also discussed. After ultimately, Supreme Court says the antecedent or the integrity of a police person is very important thing. And employer has every right to verify and examine his antecedents. If it is found wrong, then employer or any authority has a right to refuse his candidature or appointment in any post. But in this case, what happened? The petitioner misled, suppressed all these things. Even though it was come to the police verification, that one case is pending. That is, file a register FIR, and that was registered. After registration, investigation on, and police arrested 4 persons, including the petitioner, and they were sent to the jail. That is the case, my lord. It is very dangerous thing than Avatar Singh. You know, Avatar Singh case has there is a that also mentioned in this case, my lord. Now, I am reading. First of all, my lord, when the petition in this case, my lord, Anil Bhardwaj case, petitioners his selection by the appointing authority, my lord, rejected, and he was selected, but his name was subsequently deleted because there is a case filed by his wife under section 498 IPC and others, my lord, and that was registered. That much in this case. My lord, so arrest is nothing mentioned here, this much. So against the disqualification letter, when he was deleted and disqualified, against he filed a writ petition before this honorable court. The honorable high court has rejected his writ petition. Again, this the petitioner has come before the Supreme Court. The Supreme Court has categorically, my lord, referred. Lordship, kindly see paragraph 4. The appellant filed a writ.
What has happened to the criminal case against the present petition?
Present petition, I don't know, my lord. He says from the charge sheet, criminal in the chief judicial magistrate has discharged from the charges. But it is not a matter case, but his antecedent is to be seen, my lord. The why police verification is required in every appointment.
No, but antecedent to justify whether there was any criminal involvement, criminal activity.
Yes.
Isn't it?
Yes.
So that, do you think a mere filing of an FIR or an investigation is sufficient to come to a conclusion?
Yes. By this case, my lord, Lordship kindly say, I am coming in. I am coming in, my lord. Lordship kindly say, paragraph 4. The appellant by writ petition do the so and so before the High Court challenging the order of 14/9/2018. That is, my lord, removing him. The gazetted notification dated 21/9/18. The application submitted under right to information like the appellant was provided extract of the minutes of the joint meeting, administration committee, and examination selection and appointment committee. On 18/7/2018, by which proceedings the appellant was not considered suitable for being appointed to the post of district judge. On the basis of a complaint filed by the wife of appellant, the criminal case was registered and judgment dated 18/9/2019, the appellant was acquitted of the charge framed against him. In this case, this Bhardwaj case, he was acquitted, and the case is pending because after filing the FIR, case was registered. That is, they have assuming that it is a criminal case. Registered means investigation will be on. So, let's come to the paragraph 10 also, madam. The present is not a case where the name of the appellant was deleted in the select list on the ground of any concealment of criminal case against him. The appellant has brought on the record the proceedings of examination selection committee dated 18/7/2018 at item number 2 of the agenda. The committee recorded the following decision. Item number 2, consideration on the matter relates to character verification reports of the selected 13 candidates of the judicial district judge. The direct recruitment, examination 2016 and 17, received from the law department, Bhopal, for determination of the eligibility for the said post. Number 1, Anil Bhardwaj, the appellant. Attestation from submitted Sri Anil Bhardwaj and police verification report submitted by Deputy Commissioner of Police Special Branch, New Delhi, goes to show that FIR number 852/2014 under section 498A /406 and 34 IPC has been registered against Sri Anil Bhardwaj on the basis of complaint filed by Pooja, wife of Sri Anil Bhardwaj. After due consideration, resolved that a case against Sri Anil Bhardwaj section so and so under Indian Penal Code is pending, still pending before Rohit Court, New Delhi. Therefore, he is not considered suitable for being appointed on the post of district judge. So petitioner case was pending during the selection process.
No, that was a case before the court.
No, but before the court pending, his case also pending. Case was registered in 19 case was registered on the basis of FIR and he was arrested. And he applied.
Subject to correction. Subject to
Yes,
correction.
yes.
In the CRPC, there are two components. One is investigations. Once it is completed, it comes to the
Court, yes.
right?
Yes.
So now whether pendency of a matter in the stage of investigation is sufficient to say that there is a criminal proceeding pending against the petition.
Madam, that is one
or
aspect. Yes, yes.
It is only upon conclusion of the investigation when a charge sheet is filed that you can say that a proceeding is pending.
Yes. So that is two aspects, Madam, two steps. So Lordship
In Anil Bharadwaj, there was already a matter pending.
pending.
Criminal proceeding pending in so and so.
Even, my lord, even the Bhardwaj were acquitted from the charges. Even though Supreme Court says, well, I am coming to it one by
We
one.
are not on acquittal or conviction. We are on what can you say with regard to filing of
FIR and register of case. The Anil Bhardwaj case says like that. On the basis, case was registered on the basis of FIR and that is pending. And subsequently he was acquitted. But here in Abel Supreme Court analysis all the cases, my lordship kindly see paragraph 11. FIR against the appellant was lodged by wife under section so and so, so and so, so and so on the basis of by which charge sheet was submitted in court 15 July 2017 under section 498 and 406 IPC. The appellant has disclosed lodging of FIR against him in his online application form. The name of the appellant was included in the select list which was forwarded to the state. The state after character verification submitted a report which report was considered on 18 July 2018 by the administrative committee, that is the selection committee, and resolution was taken that due to pendency of the case under section 4 so and so IPC on the basis of complaint filed by the wife, the appellant is not considered suitable for being appointed to the post of district judge. And now, my lord, paragraph 13, in the midst of the judicial service, there is no dispute that on the date of when the committee declared the appellant unsuitable, criminal case against him under section 498 and 406 Indian Penal Code was pending, which was registered on a complaint filed by the appellant's wife. The mere inclusion in the select list does not give any indivisible right to the candidate. The employer has right to refuse appointment to the candidate included in the select list on any valid ground. The person who occupies judicial service of the state are persons who are expected to have impeccable character and conduct. So in the police case also, I will come later, my lord. It is not a dispute that the criminal case under section so and so IPC was pending at the time when the appellant applied for recruitment, when he appeared for the interview and when the result was declared. The character verification report was received from the state where pendency of the criminal case was mentioned, which was the reason for the committee to declare the appellant unsuitable. The submission which needs to be considered is that whether in view of the subsequent acquittal of the appellant, his case was required to be reconsidered and he was entitled to be appointed. The Supreme Court says no. Paragraph 14. This court in Commissioner of Police, New Delhi, Meher Singh, reported 2013-7 SCC 682. While considering the case of the antecedent verification form for appointment into Delhi Police Service, made the following observation in paragraph 35. Well, I am reading the paragraph 35 quoted here. The police force is a disciplined force. It shoulders the great responsibility of maintaining law and order and public order in the society. People repose great faith and confidence in it. It must be worthy of that confidence. A candidate wishing to join the police force must be a person of utmost rectitude. Simple. He must have impeccable character and integrity. A person having criminal antecedent will not fit in this category. Even if he is acquitted or discharged in the criminal case, the acquittal or discharge order will have to be examined to see whether he has been completely exonerated in the case, because even a possibility of a taking to life of crimes poses threat to the discipline of the police force. That was mentioned in the police this case, madam. And thereafter, Lordship kindly see 18, paragraph 18, madam. A three-judge bench of the court order saying, Union versus Union of India, had occasion to examine the different aspects of verification from form after selection, including the question of having criminal antecedents and pending of criminal case. Two things. Having antecedents, criminal antecedent and pending criminal case. This court laid down that in the event criminal case is pending and incumbent has not been acquitted, employer may well be justified in not appointing such incumbent. In paragraph 32, flowing has been laid down. Quoted here, paragraph 32. No doubt about it that once verification form requires certain information to be furnished, declarant is duty bound to furnish it correctly, and any suppression of material facts or submitting false information may by itself lead to termination of his service or cancellation of candidacy in an appointment appropriate case. However, in a criminal case, incumbent has not been acquitted and case is pending trial. Employer may well be justified in not appointing such an incumbent and in terminating the service of the conviction, ultimately may render him unsuitable for job, and employee is not supposed to wait till outcome of the criminal case. In such a case, non-disclosure or submitting false information would assume significance, and that by itself may be ground for employer to cancel candidacy or to terminate service. And Lordship kindly see paragraph 19. Even in case of whether candidates have been acquitted in criminal case, it was held that decision of the screening committee being not actuated by malafide regarding suitability of the candidacy is to be registered. Here now question of malafide is come, whether there is any malafide in terminating his services. And this court in Union Territory Chandigarh Administration versus Pradeep Kumar, so and so, held in paragraph 13 and 17. I am reading it. In this, it is thus well settled that acquittal in the criminal case does not automatically entitle him for appointment to the post. Still, it is open to the employer to consider the antecedents and examine whether he is suitable for appointment to the post. From the observation, this court, Maher Singh so and so and so. And paragraph 17. In a category of judgment, the importance of integrity and high standard of conduct in police force has been emphasized. As held in the Maher Singh case, the decision of the screening committee must be taken as final unless it is malafide. In the case in hand, there is nothing to suggest that the decision of the screening committee is malafide. The decision of the screening committee that the respondents are not suitable for being appointed to the post of constable does not call for interference. The tribunal and the High Court, in our view, are in setting aside the decision of the screening committee, and the impugned judgment is liable to be set aside. Next, Lordship kindly see page paragraph 22. There can be no dispute that in the event of it is found that the decision by which the candidacy of the candidate is rejected is arbitrary or actuated by malafide, such decision can be interfered with by a constitutional court. We have already noticed the judgment of the court, Union of Territory Chandigarh Administration versus Pradeep Kumar, Supra, that the decision of the screening committee must be final unless it is malafide. There can be no dispute to the above proposition, but there can be other valid reason for not sustaining the decision of the screening committee, apart from the ground of malafide. Any arbitrary decision taken by the selection committee can very well be interfered by the constitutional courts in exercise of judicial review. Paragraph 24. Reverting to a facts of the present case, the decision of examination committee of appointment committee unsuitable was based on the relevant consideration. That is, criminal case against the appellant under section so and so in the penal code was pending. Consideration which was registered on a complaint filed by a wife of the appellant. Such decision of the committee was well within the jurisdiction and power of the committee and cannot be said to be unsustainable. The mere fact that subsequently, after more than 1 year, where the person whose candidacy has been cancelled has been acquitted, cannot be a ground to turn a clock backward. So, next paragraph 30, as come to the constitution, paragraph 30 last. Thus, we are of the view that High Court did not commit any error in dismissing the writ petition. The appellant was not entitled for any relief in the writ petition. In the result, while dismissing the appeal, we observe that stigma, if any, of the criminal case laws against appellant under section 498 and 406 IPC is washed out due to acquittal of the appellant in judgment. So after acquittal, any stigma is there to wash out, my lord. We are not offered. Now question is, my lord, whether petitioner is bound to disclose the antecedents. It is important thing. Why police verification is required in each and every government employee ballot appointment? This is the important thing. If that is the theft or person and involved in the unlawful activities and even in the ballot ballot organization, that can be ballot appointed in the police department. That will be in the Assamese ballot. That is the ballot question. If it is a theft, yet he is involved in the ballot alpha activities and he has extortion of the money, then if it is appointed in the police department in the discipline post, that means what happened? What the society will survive, ballot? We and other society and all the citizens will be not in the ballot under the cover of the ballot welfare state, and they will be suffered if this person is acquitted in the police force. So petitioner apparently did not disclose and submitted false information. That is, by virtue of the office notification by the affidavit, he is still liable to be terminated from the service. And also, my lord, petitioner was in the probation. She was sent to Dehgaon for PTC for training. And during that period, that has after police verification, it come to light that in 2019, FIR was lost and the case was registered. And case was registered. FIR was 6/8/2019. In a 19 case was registered and such sheet was 21 July 2023. It is after her selection. So after her selection, that was happened. So during the process of selection, this case was registered, investigation was on, and petitioners along with other 3 persons were arrested by the police and sent to the jail. Why that fact was not mentioned? And nowhere in the reply of the second source notice ballot, petitioner rather admitted that any wrong I am ready to acknowledge. That's why this is a case, simple thing. So pending criminal cases, even this Bhordwas case also, case was pending and acquitted by him, by the court, even though his candidacy was cancelled because on the basis of antecedent and integrity of the candidacy. The police post ballot, it is very much simple. In the police case ballot, criminal case pending is very much dangerous to the society ballot. Yes. Paragraph 14. Considering the case of antecedents and verification of appointment into Delhi police made following observation. The police force is a disciplined force. It shoulders the great responsibility of maintainability of law and order and public order in the society. People repose great faith and confidence in it. it must be worthy of that confidence. A candidate wishing to join the police force must be a person of utmost rectitude, and he must have impeccable character and integrity. So that is my argument, my lord. So petitioner is really, my lord, found he has no integrity, and he did not come with a, my lord, clean hands, and he is not a, my lord, impeccable character. Our character is extortion, involvement of criminal case. So that is, my lord, whatever may be discharge, whatever be acquittal, this water case he was acquitted from the criminal case, even though he was getting discharged was upheld by the Supreme Court. Like cancellation of candidacy is affirmed. That my humble substitute lordship, I have seen in the ballot DP. I have gone through the records, but not a whisper any that there was no submission of inquiry report. There is no so and so. Rather, she was allowed to cross-examine. She denied it, and in writing, page 53. Page 53 ballot says that she says that I have no any defense witness. Then in the departmental proceeding, there is nothing wrong, irregularity. So, lordship, my humble submission for lordship, it is a fit case not to interfere with. And regarding his criminal indecency, lordship will consider it. The Supreme Court will heard us case ballot specifically said. And also, my lord, Janakiram case ballot said Janakiram case is basically for promotion. It is recruitment. My lord, I am reading he was asked whether you submit defense witness. Inquiry officer at 24 August 2024 regarding produce of defense witnesses. বিনীতপূর্বক নিবেদন এই যে মোৰ নামত চলি থকা ডিপাৰ্টমেণ্টেল প্ৰচিডিংছটো সম্পৰ্কত মোৰ সম্পৰ্কে সাক্ষ্য দিবলৈ কোনো ডিফেন্স উইটনেছ নাই, সেয়ে মই আপোনাৰ ওচৰত কোনো ডিফেন্স উইটনেছ হাজিৰ কৰিব নোৱাৰিম। Ultimately, that is the point, and an inquiry come to the conclusion that she is found guilty, and accordingly her service was terminated during the probation period. The probation period otherwise also can be dismissed, even though DP was drawn and she was given ample opportunity to defend her case. But she has failed to defend her case and produce any witnesses on behalf of her. That is my assumption. So case may be dismissed with cost.
So far, Robindro versus State of UP, that 2024 5 SCC 264 decision is concerned. This is of also a police officer. Here also.
No, you reply to the Anil Bharadwaj first.
Yes, there, first we have to see whether
Let us be clear on the fact.
Yes.
Number one, there was this disclosure which was not made by you.
No, affair was not disclosed.
You did not disclose.
In the advice of
FIR as well as your arrest and subsequent release on bail, you did not disclose. Your interpretation is that
I require to disclose whether any case pending. And on the advice of my advocate,
so therefore you have to lay down your foundation to say what is the criminal case.
Correct.
The moment an FIR is filed, can it be considered to be a criminal case, or it is only in the event it goes to the court that it can be said to be a criminal case? This is not the division bench judgment is not a protection for that.
So far the disciplinary action is concerned in the service matter, this decision come into play. However, that aiding with this decision, because there is yes, lordship has just pointed out rightly, that two stages of in a criminal case, while investigating FIR is a instrument to put certain thing for investigation by the police.
You have to give that explanation based on judicial interpretation.
Correct. So therefore, here again I am relying upon this Janaki Raman case from the 1991
Janaki Raman matter essentially is the interpretation of a
seal cover procedure.
Office memorandum.
Seal cover, yes.
Seal cover, but with regard to an office memorandum.
Correct.
Issued by the government of India.
Their question, 3 questions, para 8.
Please understand one thing, that Janaki Raman's proposition is to be understood with regard to those
facts
and the government circular.
Right.
You can't say that Janaki Raman applies in all cases.
Because I am relying on the ground, said I to devote his judgment to Diaz. 1991, 4 SCC 109. My lord, paragraph 8, my lord, that the question formulated is like this, my lord. The common question involved in all these matters relates to what is the service which has come to be known as silk over procedure, concisely stated. The questions were formulated, my lord. What is the date from which it can be said that disciplinary oblique criminal proceedings are pending against an employee? My lord, this is the first question important, my lord, for our purpose.
These are questions you have to refer it to that OM. You read the OM,
My lord.
which is extracted there in the journal.
Correct.
There is a government OM which was sought to be clarified, which caused some confusion, therefore this matter.
And my lord, in service jurisprudence, my lord, because this particular OM based on which I had to submit the affidavit at the time of my appointment, my lord, there also stated that, my lord, information that was required to furnish that whether any case pending. So here also, in a disciplinary proceeding, for a purpose of disciplinary proceeding or a criminal proceeding, when the criminal case start, answer is para 16. For the first question, on the first question, as to when for the purpose of civil procedure and disciplinary oblique criminal proceedings can be said to have commenced, the full bench of the tribunal.
See, understand the facts involved in both the matters.
Right.
In Janaki-Raman, the question was consideration for promotion.
Right.
So the normal rule says that if there is a criminal case pending, put it in Silka. Therefore, it was necessary to find out what is the criminal case and when does it start.
Correct.
In your case, you are to disclose your antecedents.
No,
this is not
the case
about
pending.
promotion.
No, case pending.
Case pending for what purpose? For promotion? For appointment?
For appointment.
No. It is to give the authority to find out the antecedents.
No.
Had you disclosed the case, it was open for the authorities to make inquiries and find out whether in spite of the case you were eligible to be appointed, not appointed. Here is a case where you did not give them any handle. You did not disclose. These are your antecedents.
Because
so therefore the Janaki-Raman case, facts are
facts are different. I must say.
Because that is only to find out when you should put it under seal cover.
Yes. Yes.
Here is a case where it is not for putting it into a seal cover or to say that there is any clarity of the advertisement to say that it must be charge sheet must be filed or charges must be there. Here is the case where you are sought to be appointed.
Right.
So background verification is required to be done, as is done in all government.
Therefore, for clarity,
unless you disclose, the employer will never know or may know later as it had happened in your case. Unless you say that no, there is a specific definition with regard to criminal case. And therefore, this is not required. It was never a criminal case.
Actually, that is my endeavor.
We'll continue in the second half.
It was passed over by the petitioner side. But I have a matter at 2 o'clock.
Deal with the court master on that.
The affidavit that no case is pending. I have not informed that the FIR is lost there. That is the admitted position. Now, if this is the admitted position, and on this point, my submission was that, my lord, that the requirement of the office memorandum by which I have to file my affidavit as a disclosure, my lord. So in that affidavit, the requirement is that whether any case is pending. So on the advice of my advocate, my lord, that affidavit who drafted that since at the time of filing the affair, no search was laid. So therefore, I stated that no case is pending.
We asked you before break,
Right.
how do you respond to the judgment of Anil Bharat?
Yes. My lord, there we have to see, my lord, whether at this point of time that searches was laid. So this is the point to be seen from that judgment.
No, from the judgment, this is not about charge sheet. The judgment is about disclosure of information.
My lord, to that effect, my lord, that their office memorandum, what is their requirement? If the requirement is for showing your past conduct, including FIR, you are to disclose. Yes, there must be a disclosure of the information FIR.
Where is that circular?
Their circular says, my lord.
Is it on the pleading somewhere?
Yes, my lord, in the affidavit, that is the from the circular, my lord. It is affidavit is page 35, and page 36 is the serial number 4.
35.
Yes, as starts as page 35 below. Annexure 8. And the page 36, para 4 is the mail disclosure. That I hereby declare.
I mean, not the affidavit. I mean the circular.
Circular, that is circular. Yes.
You're not in the pleadings.
I love that circular. No, not they have not annexed the affidavit of opposition.
General instruction is also there, but not case Roman 3. Last one.
One?
1-3. General instruction.
In the OM.
No, after OM.
After OM. After OM is the format.
Before OM.
Before OM.
The Roman page is there. Fact documents, false information, representation of the facts that lead to a rejection is detected if it is before or after the appointment.
It should be.
And sell back the candidate liable to criminal proceeding expert.
I have not been able to find it. Very good. Roman 3.
1-3. I will show you.
Page number.
Page number. Is the around the color advertisement. Advertisement and malab page 18, 17, 17.
You are referring to the advertisement.
Advertisement, then general instruction on the. I noted some point.
Yeah.
The disclosure of or non-disclosure, with regard to that instruction given, it must be.
Is the advertisement a part of the readings advertisement?
No, no.
Give us a copy from this photocopy.
Yes, I will give you. General instruction, advertisement, all these things.
You make it into a bunch and give it to us.
Oh, not so. Otherwise, maybe keep it, my lord, because I have given this all these things. In which space?
Records you retain it, but give us extracts of these particular documents.
I will give you.
My lord, now so far disclosure, non-disclosure, what are latest Supreme Court decisions, what the Honorable Supreme Court says, my lord, that in a case, my lord, Rabindra Kumar, my lord, 2004, 24/5 SCG 264, there, my lord, whether in all circumstances non-disclosure of criminal case in which candidate is acquitted, in the verification form is fatal. My lord, that question came up for consideration, and the Honorable Court, my lord, has distinguished the point that in such cases, that special circumstances under which that non-disclosure that was to be considered. This is the judgment, my lord, first para, my lord. In fact, it starts like this, my lord. The next question is back again. Is it a hard and fast and cut and dried rule that in all the circumstances, non-disclosure of criminal case in which the candidate is acquitted? Ours is research, my lord. The verification form is fatal for the candidate's employment. We think not, and it ought not to be so. Fortunately, we have a judicial supporting our view. This case will turn on a special facts and circumstances. We have endeavored to analyze the applicable precedent and have followed those lines of cases which has a striking similarity to facts. And my lord, para 2, he was the constable, my lord, Rabindra, my lord. He also did not disclose a particular criminal case, my lord. In fact, where he was acquitted. Para, the other Honorable Supreme Court's decision have been referred to. Para 22 is the, my lord, judgment of the outsourcing case. And there was when a guideline was given in the outsourcing case, para 22.
Have you shared the judgments with each other? I mean, have you supplied a list of books?
Yes, man.
To the other side, list of books you've got.
Given, my lord. List of date and list of books, my lord. I have given, my lord. And
Authorised case, my lord, it has been discussed in this Authorised case.
Yes.
He has given, my lord, 5 cases.
So, next, my lord, important paragraph is para 24.
Please, 1 minute. He has given first Janakiram case 1, number serial number 3, Muhammad Imran, and
number 3,
Ravindra, and Authorised, my lord, Authorised. These cases are discussed in this only Authorised case. And Authorised case, my lord, against him.
No, we are asking you whether you have received the list of books. Are you aware?
Yes.
Yes. Let us hear him first.
Yes. Para 24, noting from the Authorised judgment, my lord, also notice that the judgment commission.
No, what are the questions here?
Yes. Question is that, my lord. Question is that, my lord, the first paragraph itself, whether non-disclosure of a criminal case in the verification form is fatal for the candidate's employment. Well, this line is important there too, so I was trying to show my lord. Para 24, quotation, paragraph 12, Roman manner. It is true that in the application form, the respondent did not mention that he was involved in a criminal case under section so and so. Probably he did not mention this out of fear that if he did so, he would automatically be disqualified. At any event, it was not such a serious offense like murder, docility, rape, and hence more lenient views should be taken. The Honorable Supreme Court has gone into that aspect of the material law. And finally, particular case, my lord, since the appellant was already acquitted, the Honorable Court, para 34 is the, my lord, the finding in fact. 34. It has said, my lord, special circumstance. Para 34 may read, my lord, on the facts of the case and in the backdrop of the specials set out herein above, we thus the non-disclosure of the unfortunate criminal case to even ended in acquittal stand in the same scheme of things. In our opinion, the particular facts of the case, we do not think it can be deemed fatal for the appellant. Road pursuing every non-disclosure of disqualification, it will be unjust, and the same will be tantamount to being completely obvious to the ground realities obtaining in this great, vast, and diverse country. Each case will depend on the facts and circumstances that are prevailing thereon, and the court will have to take a holistic view based on objective criteria with the available precedent serving as a guide. It can never be a one-size-fits-all scenario. For the reasons we set out herein, the appeal is allowed, and the order of London single just include order of division special appeal number so set aside. The order is of the third respondent. Commandant is was the respondent is directed to appoint appellant in service on the post of constable for which he was selected. All of that was interfered with. And another judgment, my lord, in Muhammad Imran versus Maharashtra, State of Maharashtra 2019-17 SCC 696, their Honorable Supreme Court said, my lord, employment opportunities are
What is the ultimate finding in the judgment that you have referred?
My lord, they are, my lord, said, my lord, under what circumstances he made the disclosure, my lord. And if in such cases, my lord, acquittal is recorded, so that circumstance was to be considered.
So
My
these
case-
facts are different here.
My case is,
Your facts are different. At the time when you had submitted, there was no acquittal because the case was not even registered. I mean, it
yes.
was not, the charge sheet was not filed.
Here also, my lord, that the acquittal is subsequent.
Is there an ever been that effect?
Yes. Yes, my lord, kindly say para 3, my lord.
Para 3 of?
The judgment, my lord, Robindra Kumar, my lord. 2020.
No. In your case,
Yes.
have you made a statement in the pleading somewhere that finally you are acquitted? Or
Yes, yes.
FR was submitted?
Next, my lord, that is the Annex 13, my lord. Annex 13, page 71, my lord. In my affidavit in reply, I have annexed that, my lord. This is order 13/6/2025. The list of date serial number 14. I have stated. The list of serial number 14, 13/6/2025. Petitioner was discharged by the Judicial Magistrate First Class. Review in the PRC case number 1165/2023. So
Yes.
therefore, my lord, I would not have a case, my lord, if, my lord, I have not been either discharged or, my lord, acquitted by the competent criminal court. So, in my case, the special circumstance is that, my lord, keeping in view that those who had the allegation in the FIR, my lord, during the investigation of a particular thing which were put through an FIR, alleges, and this they have forwarded before the competent court on 21/7/2023, my lord, serial number 6 in the, my lord, list of them. So, till filing of the search sheet, the FIR was in investigation. If the FIR was in investigation and the court proceeding, my lord, judicial process start, my lord, the judicial process has been defined under 2H of the, my lord, the CRPC. Presently, Bharatiya Naik Suraksha Sanhita 2023, my lord. If I read from the, my lord, the CRPC, judicial proceeding defined under 2I, my lord, includes any proceeding in the course of which evidence is or may be legally taken or not. Now, what is the investigation?
No. What you have to give clarity is the matter is to the definition of criminal case,
Right, my lord, right.
not judicial proceeding.
Correct. Therefore, what is
the criminal
investigation?
case? Does it include the investigation or not? As per the this is the requirement in the notification and the format.
Right.
Right?
Right.
So according to you, say it is not a criminal case.
Correct.
Because there was no charge sheet filed. Ultimately, I was discharged. So according to the department, it is some criminal activity was
Right.
there, FIR was there, you were arrested. So you can't say that there was no criminal.
Well, investigation has been defined, madam. Criminal case, I will come to the judgment, madam. Investigation 2H, what is investigation that defined 2H, madam, includes all proceedings under this code for the collection of evidence conducted by police officer or by any person other than minister who is authorized by the minister on his behalf. Police making investigation after getting information, this is investigation, madam. Until and unless police come to a conclusion, my lord, and file the search sheet. So that is the judgment, my lord, what I found. And in the morning, my lord, further I relied upon before the Sonapur court. This was the argument made. Again, if I may be allowed to rely upon 2001 3CLT 389, my lord. This is full bench judgment of the Sonapur court. My lord, here also, different judgments of the various honorable high courts. My lord, this judgment was now. What is criminal proceeding that was, my lord, argued like this, my lord, in this judgment, para 9. Criminal procedure. Para 9, my lord, it's the criminal with the rule of law governing the procedure by which crimes investigated, prosecuted, adjudicated, and punished. Generic term to describe the nature of law and rules which govern the procedural administration of criminal justice. Example, laws and court rules. Rules of criminal procedure governing arrest, search and seizure, bail, etc. Compare criminal law. Now, so far judicial proceeding, my lord, Mr. So-and-so, counsel draws attention to 2H and 2I of the CRPC. Define investigation. Investigation includes proceeding under this code for collection of evidence conducted by a police officer by any person other than the magistrate who is authorized by the magistrate's behalf. And 2I defines as judicial proceeding. Any proceeding in the course which evidence is or may be legally taken on oath. Now, my lord, diversion, my lord, view of the different high court, kindly see para 17. Now, para 17, my lord, this is the, my lord, view of the Honorable Bombay High Court. No doubt, para 17, my lord. A 1940 Bombay 414, my lord, in the case law was laid as follows. No doubt, the criminal law may be set in motion by giving information to the police of cognizable offense, but unless proceedings are instituted in a court of law, it is not correct to say criminal proceedings have been instituted. Well, it's a categorical finding of the Honorable Bombay High Court. A mere charge, however serious, example, Dokaiti, which goes no further than a police inquiry, does not give rise to a case triable only by a court of session. If the matter gets into the court and a man is put on his trial on a false charge, that is much more serious matter. If the case gets no further than a police inquiry, it does not fall within second part, but fall within the first part. Section 211 can be tried by first minister. This is what the police found in the investigation. Those material will be placed before the court. Court will take cognizance or search at the time of closing of the search. That can be said. Criminal proceeding is instituted. Next, my lord, Rangoon High Court, then para 19. This is the Honorable Nagpur bench, my lord. Investigation by a police is not a criminal proceeding against any person, and therefore setting the criminal law in motion by making a search to the police of a cognizable offense against the person does not amount to the institution of criminal proceeding against that person within the meaning of the second part of section 200 CRPC. This was relied in Honorable Calcutta High Court in the decision, and Madras High Court also. And now our Honorable High Court pays para 20, again read, we are in the respectfully agreement with the decision of Allahabad High Court, Bombay High Court, Nagpur High Court, Rangoon High Court. Even if the decision of the Calcutta High Court and Madras High Court are also made applicable, that also will not change the color of the present case. As a matter of fact, there was no need for use to decide the question, but it was been decided by because it was ours and argued vehemently by the learned counsel for the we hold that a criminal proceeding comes into existence only when the matter comes before the court and not earlier to it. My circumstance here in this present case is that, I was required to divulge the criminal case.
We'll continue hearing.
My lord obliged.
Lord. Order hearing. Third September. 3rd September.
For order.
We are keeping it for hearing, let us see. If we need any clarification, we'll follow.
Obliged.
Yeah, we will agree. This can be- Yes.
Lord had heard this matter once earlier. The only issue raised or the objection was regarding limitation. Sure. Should be fine. I forgot, right before your lordship was rising, I think he charged me.
We wanted to, but I think it was agreed that the matter will be called up in the second half.
That's right.
If he's not present, we can have it on some day.
Can it be taken up on 4th? That is the date he was proposing.
4th. 4th is the
Tuesday.
4th of August. Release this matter again on 4th of August.
Obliged.
As requested for, I think.
Item 56.
Yes. Yes, Mr. Das.
Yes, my lord. Long back, your lordship heard this matter once, but it was quite a
Is it necessary to keep it parted?
My lord, let just pretty
has heard once, lordship can take up the matter.
Lordship, there was an order on, I'll take your lordship to order it at 6/5/25, my lord. 6/5.
5,
6/5/25, my lord.
5/25.
My lord.
Yes.
Look, we had filed an affidavit where we had taken a stand that the discharge certificate, which was submitted by the petitioner, the bank, and the discharge certificate, which is annexed in the writ petition, they do not tally, my lord. The discharge certificate, which was submitted to the bank, you were shown as a general caste. And the discharge certificate, which is annexed in this writ petition, my lord, he has shown as a scheduled caste, my lord. The same document, my lord, there is a discrepancy, my lord. So we prayed that the original discharge certificate may be produced by the petitioner to ascertain, my lord, whether which is right and which is wrong.
That was produced.
Not produced.
Not
No,
produced.
I have got this.
So you were in the Air Force, then after
Yes,
that
sir.
you were in the employment of the bank.
Yes.
Then what happened?
Then, my lord, there were some allegations, and pursuant to those allegations, my lord, they have imposed penalty, major penalty of reduction of pay.
Reduction to 2 stages, my lord.
Reduction of pay by
Reduction of
2
rank.
stages. I'll just show.
But not termination.
No, it's not termination, it's reduction of pay by 1 stage, my lord.
I think it's better to release it because right now the roster has changed. So you have to rehear the matter.
Obviously, lordship will not remember. That's true.
Rehear the matter.
SC certificate.
Unless you say, no, it's on a very short term, we will finish it in, wrap it up in one day. Put an exhaustive hearing, then Friday the month, back to the roster. Judge.
Try to finish your, as, as within limited time, my lord. Try to finish it off. I'll not take much time. Sir, it's certificate. Hello. Oh. Hello, what is your certificate of SC9? No, no, it's not correct, is it? Correct, is it? White number is it? No, no, so here. White
We
number,
will,
yes,
all right, we will take one more attempt to finish it off on 13 hours.
13, my lord, I have some personal problem. Next week.
Then 20,
Can it be on 18, my lord? Tuesday.
then 18. 18 hours.
18.
Parties are agreed that quiet hearing.
My lord, 18 also suffer. I have another secret matter, my lord. I have another secret matter. We'll try, my